You say you are calling me. I've not seen any missed call
I
from
don't know.
you.
I've been calling. All the same, let's just quickly take your thoughts on the recent Court of Appeal judgments. Particularly, let's start with Plateau State. Like we heard from one of our callers who just spoke before you called my line. He's asking, what about the Supreme Court judgments that talked about pre-election matters and matters being private affairs of political parties? Why are we not seeing that play out in, for instance, cases like that of Zamfara? Probably, yes, Kano and now Plateau. Over to you.
So quickly, you see, these issues are distinguishable depending on the set of facts. For that of Plateau, if you remember, it is similar to what played out in Zamfara and Rivers State in 2019. Remember in Zamfara and Rivers State in 2019, there was a crisis, internal crisis of the political party there, the APC, between Aziz Yari and Senator Marafa. And so Congress that produced the members, the executive members, were not conducted as at when due. So they were not conducted within the time for conduct of Congress. And the court held that not conducting Congress, that there were no validly elected officials to now elect candidates, contestants who will contest on the platform of the party. In Plateau State, for example, there is a Supreme Court judgment that asked the PDP to conduct Congress in 17 local governments. The Congress were not conducted in the 17 local governments. Rather, they did Congress in 5 local governments only. And on the basis of that, now imposed candidates. So at the tribunal, for the governorship election petition, the court closed its eyes to that Supreme Court judgment, claiming that they didn't want to go into the matters of pre-election matters of the political party. But subsequently, the same tribunal, in hearing the election petition of members of the House of Rep and members of the House of Assembly, held that the refusal to conduct Congress was fatal to the nomination of candidates, and so that those candidates were not in the first place qualified, as held by the Supreme Court in that Zamfara case. So, but some queried those inconsistencies that in one breath for the governorship, you heard that the Congress it was immaterial. But for the House of Assembly and House of Reps, you are now holding that failure to conduct Congresses was fatal. I think it was in that light that the Court of Appeal came down heavily on the judgment of the tribunal yesterday when they said that judgment was incompetent, that the judges of the tribunal ought to have taken cognizance of that Supreme Court judgment, holding that PDP should conduct Congresses in 17 local governments like it happened in Rivers. That's the case of PDP. The case of the NNPP, that's the case you can now say that the court ought not to have even begun to discuss the issue of candidature of the NPP on the ground that the Supreme Court had laid that matter to rest. In the case of Peter Obi, remember the APC did file a cross appeal contesting the candidature of Peter Obi, and the Supreme Court said no, that the candidature of Peter Obi was an internal matter, having left the PDP and joined Labour Party. As when he joined Labour Party was immaterial to the APC, and that he was the Labour Party had complied with the rules for feeding candidates, and that he was not in dispute, and that the PDP at that time could not even contest the candidature, that it is only somebody who contested the primaries with him that has the power to contest the candidature. That has been laid to rest. Also, the second plank of the APCs of the tribunal judgment also in Kano, I will also fought on the ground that the tribunal heard that ballot papers were not marked by INEC, and so to that extent, those ballot papers were irregular and expunged. If you look at Section 63 of the Electoral Act, Section 63 and sub 1 and 2, particularly I want to read sub 2, but let me start from sub 1. It says, subject to subsection 2, a ballot paper which does not bear the official mark prescribed by INEC shall not be counted. That is at the counting of ballot papers.
All right.
But subsection 2 now says, if the returning officer is satisfied that a ballot paper which does not bear the official mark was from a booklet of ballot papers which was furnished to the presiding officer of the polling unit in which the vote was cast for use at the election in question, he or she shall, notwithstanding the absence of the official mark, count that ballot paper. So the tribunal also, that's why I wonder where the Kano tribunal, those two issues that they ruled on, I wonder where they got their own precedent from. That's where I have problems with that.
Liborous, yes, very quickly, just because of time. What about the instances where the Supreme Court had, and even the Court of Appeal or the Presidential Election Petition Court had said that issues that are pre-election matters won't be entertained because they're solely the parties and members of the party?
In the case, that's what I'm saying, that for the Kano State, that judgment of the Court of Appeal is inconsistent with the position of the Supreme Court.
What about
completely inconsistent.
What about that of Plateau State?
Plateau State is a different matter. It is like what happened in Zamfara, where you did not conduct congresses, and the Supreme Court, the matter went as far as the Supreme Court, and the Supreme Court held that failure to conduct congresses, you shall not free candidates, that you should go back and conduct congresses in 17 local governments, which you failed to do.
All right.
So at that point, that is not membership of political party. It's no longer an issue for membership of the political party.
Yes,
it's different from Kano.
Okay. Counsel to the PDP, Emeka Teba, he raised an issue which is quite interesting. He said the petition was bordered on a nomination, but the judgment was talking about sponsorship, which was not contained in the petition. What's your take on that?
The issue is the fact that the court at some point have the power to take judicial notice of judgments of Supreme Court in respect of issues. That is
even
why
when they're not included, even when they're not included in the petition.
Look, there are responses. The response of the APC in this case is the fact that there is a subsisting court judgment that had held that the PDP should conduct congresses, and failure to conduct those congresses means that the PDP does not have candidates. So you can't close your eyes to the judgment, a valid judgment of the Supreme Court on the preliminaries for the election. There are procedures for feeding candidates. You must conduct Congress. The Congress will produce elected officials. And these elected officials will now subsequently, in collaboration with your National Working Committee, conduct primaries to feed candidates. But in the absence of a valid Congress, which is the foundation for all of the candidates that will be nominated, in the absence of that, the court cannot close its eyes to that. It is different from when somebody joins a political party. You join a political party, and then they now say, "Oh, look at that! When you join the political party, that you cannot, you were not a member, or that your name is not on the register." Just like the case of Peter Obi, and the court said, "No. In as much as the political party has accepted that member, you can no longer begin to query whether he's a member of the political party or not."